Welcome everyone again to the University of New Mexico Law and Mental Health Didactic Series, hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have all of you joining us today. I'm Dr. Anthony Perillo, the Forensic Psychology Training Director in the Department of Psychiatry and Behavioral Sciences here at the University of New Mexico. A couple of things before we get started today. For our talk today, if you have any questions for our presenters, you can ask them in the Q&A box that is in your Zoom monitor anytime you feel comfortable. Just know that we hold the questions until the end. We do try to get to as many as possible in the time frame that we have. Just forgive us if we can't get to yours. If you are pursuing continuing medical education credits, there will be a sign-in sheet that is posted in the chat very shortly. And those of you that are pursuing APA continuing education credits, that link will also be posted in the chat, but around the last 5 to 10 minutes or so of the webinar. Make sure you open that link before you close the webinar because we don't have the link to share after the fact, and make sure you download your certificate after you complete the survey because we don't have access or able to keep copies of those surveys. A recording link and PowerPoint slides for this talk should be available sometime later this week. And as a heads up for next week's talk in the series, we have Dr. Tina Zatoli, who will be discussing competency and validity issues of guilty pleas among youth. That's for next week. Now is the time that we've been waiting for. I'd like to introduce you to today's speakers who will be discussing juvenile competency restoration and particularly the LEAP Outpatient program. This is Dr. Toni Walker and Dr. Florencia Iturri. Dr. Toni Walker is a postdoctoral fellow at the Harris County Juvenile Probation Department Forensic Unit in Houston, Texas. She graduated with her Ph.D. in clinical psychology from Louisiana State University after completing her predoctoral internship in the University of Tennessee Health Sciences Center in Memphis. While on internship and in her current postdoctoral position, Dr. Walker has conducted competency to stand trial and fitness to proceed evaluations with juvenile and adult populations. On postdoc, she's provided outpatient fitness attainment services to legally involved youth at Harris County Juvenile Probation Department and has assisted with the development of the Legal Education Attainment Program, the LEAP program that is the focal point of this talk. Dr. Florencia Iturri is a staff psychologist at Harris County Juvenile Probation Department of the same forensic unit. Dr. Iturri received her Ph.D. in clinical psychology with an emphasis in forensics from Palo Alto University. She was previously an intern and forensic postdoctoral fellow at the Harris County Juvenile Probation Department. She has experience conducting forensic evaluations with juveniles, providing treatment to detained and post-release youth, and within the court system. Dr. Iturri is originally from Bolivia and provides all services in both English and Spanish. She helped develop LEAP, an outpatient competency restoration program for juveniles that launched in the summer of 2022 and is currently the director of LEAP. She's published in peer-reviewed journals, presented at conferences, and received research awards for her dissertation award work, including the Diversity Research Award from the Bridge Minority Affairs Committee from the American Psychology Law Society. Dr. Walker, Dr. Iturri, on behalf of the University of New Mexico, can I say how honored and excited we are to have you joining the series? Thankful for you sharing your expertise and sharing this work on a program that you have helped kickstart. I am now going to throw it over to you.
Thank you, Anthony. We're excited to be here to talk about our LEAP program. So Dr. Perillo, thankfully, I could run through our bios here. And there's some information regarding the CEUs that he went over, information for our disclosures. Okay, so first I want to jump into our learning objectives. So at the outset, we'll discuss kind of the legal circumstances related to competency restoration services. And then we hope to analyze specific needs of juveniles in restoration services. And then finally, just addressing specific challenges for youth and practical applications for juvenile outpatient fitness attainment. Okay, so what is competency? Specifically, this is the defendant's capacity to be able to engage in their legal process and function meaningfully in their court proceedings. This is a present-focused ability, so in comparison to what you might understand as like insanity or mental state at the time of the offense, which was referring to their mental state at the time of the offense. This is a more present focused ability, and as such, it can change over time. This applies at every stage in the legal process, and it is both task and moment specific. I do also want to kind of clarify at the outset that some of our terminology is a little bit different in our juvenile system. So as I'm going to be using the term competency, competence restoration, just because that's a more widely known term. However, in our juvenile system, we tend to use the terminology of fitness to proceed or fitness attainment in reference to what you may know as competency restoration. Okay, so why is it important that a defendant or juvenile is competent? And notably, or firstly, this is to ensure their constitutional protections of the defendant. So they have a right to understand the proceedings against them and to understand kind of the charges that are faced, that they face, as well as the potential consequences of those, and to understanding the legal process. Punishment is only morally acceptable if people can understand why they're being punished. And so pursuing legal proceedings for an incompetent defendant violates these rights. So this is to preserve the dignity of these proceedings. And secondly, to improve the accuracy of conviction. So they also have a right to aid in their defense. So that is to provide exculpatory evidence and assist their attorney in providing the best defense for them. And so by ensuring that this defendant is competent, they can assist in providing the best defense. And then lastly, to ensure the autonomy of the defendant. So there's decisions that they may need to make specifically for plea agreements or the decision to testify in their proceedings that hold a lot of weight in terms of the consequences for their case. So by ensuring that defendants are competent, we can ensure that they are able to knowingly, voluntarily, and intelligently make decisions of whether or not to engage in these certain or weigh these certain decisions. And so the most widely known standard here is the Dusky versus US 1960 statute, which outlines 3 prongs to address competency. So factual understanding, rational understanding, as well as the defendant's ability to assist with their counsel. And so factual specifically refers to the facts and knowledge that they have about the court proceedings, the roles of key court players, and their charges as well. And then rational kind of builds upon this and how they're able to apply these facts and knowledge to both their case as well as to other cases. So it's one thing that they're able to identify their defense attorney, or identify kind of facts of their own case. Can they apply this information to other situations or other cases? So a defendant can have factual knowledge while not having that rational, but you can't have the rational without the factual. And this is just to ensure that they haven't just kind of memorized or are able to just parrot back definitions, and that they truly can understand how certain situations or certain decisions can apply to their case. And then lastly, the ability to assist in their counsel. Are they able and willing to discuss their case with their attorney, and are they able to tolerate and attend during court proceedings? And so there's no Supreme Court case law that's guiding juvenile competency procedures. In Texas, here we have Chapter 55 of the Texas Family Code here, which has us identify whether by reason or by mental illness or intellectual disability, the juvenile lacks capacity to understand the proceedings in juvenile court. Panza et al. 2020 identified about 37 states that have juvenile competency statutes. About 10 of the states just reference kind of adult criminal code, Texas kind of included, as well as 4 states have no statutory guidance. So again, this is kind of Texas specific, and that'll kind of guide us in today's presentation. But just important to know that we do need to identify the reason for the lack of fitness. So again, whether that's due to mental illness or intellectual disability. And so this is one kind of difference between our jurisdiction as well compared to the adult jurisdiction, that we do have to identify that qualifying reason and state whether or how that qualifying reason, whether that be mental illness or IDD, impacts those capacities. And so diagnosis alone does not qualify an individual to be found unfit or incompetent. So just because an individual individual has an intellectual disability or they're psychotic or manic does not necessarily mean that they're incompetent, so they can still be fit. What matters specific to youth is that what they're capable of doing rather than their diagnosis. And then comparing more specifically youth to adults, these are kind of several diagnoses that we see in the youth system, some which may be different than compared to adults with reasons that an individual may not be competent or fit. So kind of more common in juvenile ADHD, autism spectrum disorder, intellectual developmental disorders, and mood disorders as well. Less commonly, we see psychotic disorders, just generally because that age of emergence tends to be in that young adulthood period. Not to say that we don't see that, but it's less common, especially compared to adults. And while youth may have these disruptive behavior disorders, more commonly compared to adults, these are less likely to be related to their fitness. And so with youth, we're looking at how this mental illness impacts or the intellectual disability impacts their knowledge and abilities. So while adults are presumed to be competent until they're proven not, with juveniles, we're assuming that they often lack that knowledge, which I'll get into a little bit more later. And then specific to their expectations of ability, so kind of what I was just referencing, the adults were looking at that specific impact on their ability, whereas with youth, that lacks capacity is kind of the focal point of what we're assessing and addressing as well during restoration procedures. So again, just focusing on their capacity rather than their knowledge or their ability at the present time. So this mostly impacts the evaluation of their fitness, but it also affects how we treat a lack of fitness. So with adults, most commonly you will probably see medication as a primary target for restoration, whereas juveniles, we're trying to kind of build upon that capacity, as we commonly see developmental disorders and intellectual disability impacting or being the reason for a lack of competence. And so again, kind of more common problems found among youth who are not fit, limited knowledge. Again, like I mentioned, we're assuming that they kind of don't have that baseline knowledge because they have less exposure to the court system compared to adults. Also due to developmental disorders or borderline intellectual functioning or IDD, they may have a limited capacity to understand and acquire these abilities or these capacities. I'm sorry. With attentional deficits as well, related to ADHD, trauma, depression, this may impact their ability to attend to the information and concentrate enough to retain it in their memory, which we'll touch on a little bit in our case example that Dr. Iturri will be presenting later. And then communication problems related to a variety of disorders may impact their ability to both understand and communicate with others. I also want to include here too, something that's kind of emerged more recent in the research is the discussions on how developmental immaturity impacts youth fitness or competency. So things specific to skills and abilities that naturally develop over time, such as decision-making skills, ability to weigh costs and benefits of decisions, future orientation. So things that develop naturally over time are more common to impact youth, especially younger youth, and be a reason why younger youth are found not fit. And so this is consideration both for the evaluation of fitness as well as the treatment of fitness. And it raises questions of if it is kind of solely that developmental immaturity, separate from kind of a mental illness or intellectual disability, how do we kind of treat that if it's more so a function of time? And so here's an overview of kind of services that may be needed when it comes to restoration or remediation services. So specifically medication, as I mentioned before, is more commonly found among adult populations, but also with our youth as well. They may also need psychoeducation too. Therapy services to address these underlying issues that may impact their fitness, and to develop different skills to reduce those symptoms. And then legal education, which is the focus of this talk here. So it's more of a formal process where we're addressing kind of their specific limitations, whether it's that rational or factual, or their ability to assist with the counsel. And then kind of within those, kind of what specific areas are they lacking or need more support in. And so the need for outpatient programs emerged from recommendations of best practices for providing restoration or fitness attainment services in the least restrictive setting, in addition to considerations for how to handle youth that don't necessarily meet commitment criteria for inpatient settings, as well as to account for the backlog of admissions to state hospitals, which ultimately result in a delay of services to youth, since we do have a delay in admissions, especially here in Texas. Then you have youth who are kind of sitting, there's a stay in their proceedings, nothing's really moving forward when it comes to restoration. And so it's putting a lot of burden on state hospitals, especially because they've been seeing an increase in competency restoration patients over the last couple of decades. So this kind of brought forth the need for outpatient programs to be seen in settings where we can kind of address these limitations of these defendants in a setting that they may be best fit in. And so, as you see, are listed out some of the sites of these youth fitness attainment programs. These programs are typically modular, so youth will kind of progress through the program in addressing certain skills once they've kind of established, I guess, competency, for lack of a better term, in previous skills. Most of them are based off of adult programs, and some run in group versus individual formats. And so there's also recommendations that youth in less restrictive settings, so for outpatient, they should have longer periods of restoration than youth in more restrictive settings. And this is because they're in the outpatient settings, it's not much of a consideration of kind of their civil liberties being violated. And they will likely need less kind of intensive services. And so, as you see here in our Texas Family Code, we kind of go by the 90 days that the inpatient hospitals go by, but we do advocate for, or we are advocating for increased time to abide by those best practices. So giving us more time doesn't necessarily mean that the youth will use more time. Warren's study of their outpatient program in Virginia noted that about 52% of the youth were remediated within that 3-month period that we get within 90 days, but an overwhelming majority had determinations in the court within that 6-month period. So a lot of youth would benefit from that increased time, but that doesn't necessarily they may need that full time. But giving longer time also does allow for flexibility and provision of services. So some of the things that we've come across that we'll talk more about later are needing more flexibility in time when it comes to just the youth getting sick and missing sessions, or they're having particular difficulty with a certain module, so we need to spend more time on that. So allowing a more extended period of time will give us that flexibility. It also reduces the burden on families. And in contrast to inpatient, where they're being seen more intensively, this will allow us to kind of ensure that they get the full services. So here in Texas, in Chapter 55, we have the state hospitals to complete full fitness evaluations at the 75th day. So we're kind of bound by that 75th day, where we need to provide an update on the services that they received, as well as opine on whether they're fit or unfit. And this sometimes leads to issues because at that 75th day mark, that's about 4 or 5 lessons before they reach that 90th day mark. So, and usually those lessons are used to review, they're used to review some of the areas that they may have trouble with. So we're kind of missing those couple sessions. So having that extended period may help provide that additional support that youth may need. Sorry, I'm having trouble with my slides.
So while Dr. Walker works on that, we wanted to talk about the LEAP program. So Dr. Walker kind of alluded to why the LEAP program exists. What we found in Texas and in Harris County in particular is that we were having more and more youth who were not fit to proceed, but that also didn't meet the criteria for commitment. And so in Texas, criteria to be committed includes that you have to be an imminent danger to yourself or others. And we had kids who definitely had involvement with the legal system and who were definitely not fit to proceed, but who did not meet that commitment criteria to need to go to the state hospital. And some of these youth that we felt we could serve in the community or in our facilities or wherever it was that they were without having to wait sometimes a year for a bed at the state hospital. And so sometime in 2022, sometime in 2021, one of our judges came to us and was just like, hey, y'all are writing in your reports that these youth are not fit, but that they don't necessarily meet criteria for the state hospital. Can you create a program? And it was COVID and we had time on our hands. So we decided that, yeah, we could look into what was out there. Also, Dr. Walker, I'm still seeing the same slide. I don't know.
Yeah, I'm trying.
Okay, cool. So I'll just keep talking in the meantime because our slide just has the title of our program.
Okay.
So we started to try and create this program. And the first thing we did was look elsewhere to see what else exists, what else is out there. And like Dr. Walker mentioned, there were some places like Utah, Colorado, Florida, Pennsylvania, and Virginia who had created some kind of procedures. Some were freely available, others were not. Most of them were based out of the adult system. And at the time, because it was COVID, we were also trying to find something that maybe we could possibly administer online because a lot of our kids could not make it into our facility or were at home. And so at the time, we decided to meet with everyone that we could think of, from our defense attorneys to our prosecutors, judges, to all sorts of experts. Special shout outs to my co-creator, Dr. Iturri, but also to people like April Alexander, Neil Gowan-Smith, Patty Zaft, who all dedicated time to meeting with us to talk through our questions and doubts. And so from all of that and a lot of effort, we created the LEAP program, which stands for the Legal Education Attainment Program, which we created based off of the program that was designed by the Department of Human Services in the state of Utah. And the state of Utah is currently one of our co-collaborators. We meet with them all the time. Jackie Heel is the lead over there. And so we're gonna walk you through how our program works, but our hope is not just that you get something from our program, but that you get something about how to do this kind of restoration with kids if you needed it. So if you could go to the next slide. The first thing that we had to decide is who meets criteria for being part of LEAP, because not every kid is going to benefit from LEAP. And so the first step is that they have to be determined to be unfit to proceed by the court, and they can't meet commitment criteria. And for us in Texas, that means that they're not an imminent danger to themselves or others due to a mental health or intellectual disability. And then we are also asking that youth be court ordered to participate in LEAP, because we need all the legal entities to be on board with them receiving our services. Some of our exclusion criteria is that if they are determined to be not restorable, then we're just going to follow that recommendation, and we tend not to offer those services. But also we need youth to be able to participate either in person or online. Now, some cases we might decide that online services are not appropriate. We've had some kids, for example, whose offenses took place online, and the judges were not comfortable with them participating online. We have other kids that, due to their presentation, are not going to be able to pay attention to us online and are going to need more of a connection. And then we have other kids due to financial difficulties or other systemic issues, don't have access to a computer or the internet. So for them, online is also unreasonable. Despite many, many attempts, we have found that in-person services work best. And so I don't know if we're going to continue to do the online services, but it is part of what we wanted to offer. The other big thing is that we are now screening parents and youth to see if they are willing to participate and to work with them on getting them ready to participate if they don't want to do so, because otherwise it ends up being not successful. I think it has crashed again. In the meantime, I'm going to tell you about our program details, which is the next slide. We're very lucky here at Harris County that we have a big training department. So we have several people who can collaborate on LEAP with us. We have our postdoctoral fellow, which this year is Dr. Toni Walker. We'll also have staff psychologists such as myself, and we have interns that we work with. So the general process for this is that either our fellow or the staff psychologists who do fitness to proceed evaluations, or our staff psychiatrists will conduct that initial evaluation, decide that the youth is not fit, that they don't meet commitment criteria, and they will recommend LEAP. At that point, it will go up to the court and the judge will determine fitness, and they will also order LEAP services if appropriate. Once a youth is referred to us, we immediately start meeting with them, with the parents, we review their services. I, as the LEAP director, I'm the one looking over all of those services, so I don't complete the initial fitness to proceed evaluations, but I do review those evaluations so that we can create a treatment plan, looking at what are the specific areas of deficit, what are the specific reasons why we're having deficits in those areas, what do we think the best modality to continue will be, things like that. On average, most of our youth receive 1 hour sessions 2 or 3 times a week. So we're meeting with them for about an hour, which is usually all that they can stand in terms of attention and paying attention to us. And we're meeting with them 2 or 3 times a week, depending on the week, depending on the youth, and also depending on the ability of the parents to bring them in. Some of our youth have received these services in detention, and so with them, it is much easier to meet with them 3 times a week. But if they're in the community, we also don't want to create such an added burden to the parents that it causes more strife.
Okay, sorry, Dr. Iturri. I was going to ask if you could bring up the PowerPoint because it is breaking out on my computer and keeps shutting it down.
Let me try that. Are you all seeing just the presentation?
Yes.
Perfect.
Yes.
Okay, so this is what I was kind of talking about. So once the youth starts receiving services, we are providing monthly updates to the court on how they're doing, if they're attending, if we're progressing, if we're having difficulties. We also tend to provide informal updates to their defense attorney, especially if there's information that we need from them. And then, like Dr. Walker mentioned, by the 75th day in the program, we do conduct essentially what is another fitness to proceed evaluation to say whether the youth is fit or not, and to say whether they're going to need those 4 to 5 sessions of review if those are recommended. And we will go over a little bit later, like what happens at the end of those 75th days, like, and the different potential outcomes that you can get. One of the things that I want to discuss before we go forward, because we don't have it in a specific slide, is that in Texas, these services are not protected in terms of being able to be subpoenaed. And so this is not sealed for only fitness to proceed procedures. And therefore, one of the things that we don't do is we are not allowed to discuss the youth's offense with them. And that is something that would change, obviously, jurisdiction to jurisdiction, but it's something to keep in mind as we go forward with these. And I will talk more about that again later. So when we were creating LEAP, some of the principles that we had behind it is that we wanted it to be interactive and engaging. We are dealing with teenagers, so we wanted to keep their attention. We wanted to be developmentally appropriate, and that was the biggest change that we saw was needed from the other existing procedures that we were able to get. So many of them were geared towards adults that it felt like the language was too complicated, the steps, the activities were all too adult focused, and we wanted something that was more developmentally appropriate, especially for our youth with IDD. We wanted to be defense attorney approved. And so we were very lucky that our public defenders looked at all of our materials to make sure that what we were teaching was correct, but also that it was to the degree that they would need to be explained and the things that they would need the youth to be able to do. And we wanted it to be customizable. We know that not every kid needs the same level of services. They also are not going to be having the same kind of experiences through court. So we wanted to be able to give them what they needed. And the youth learn about the legal system, legal terms, court processes, their rights, court personnel, how to behave in court, how to communicate with their attorney, and sometimes other skills if we think that they are needed. We use a modular process. And so these are the 10 modules that we have. One of the questions I got asked the last time I made a presentation around this is like, okay, but where are you teaching like factual and where are you teaching rational? And the truth is that we teach them concurrently. We find that factual understanding has to come first because it is very hard to teach someone how to rationally think about something if they don't know what that is. But you cannot separate the rational into its own component. And so we build on the factual to get up to the rational understanding. And then throughout, we're also working on then how do you do this with your attorney? We are researchers at heart, and so we are trying to measure progress as well. One of the things that we do is before every module, we administer a pre-test, and then for every module at their completion, we administer a post-test. In general, we spend a lot of time thinking about what is good enough in order to have fitness, and after talking to a lot of people, we decided that an average of 70% was considered passing for having completed the module. There are some caveats to that. There are some questions or constructs that if you don't get They are so big or so important that we cannot move you, even if you have a 90 on the rest of it. So for example, if you truly believe that a judge cannot be impartial, or don't understand what impartiality is, like, and you think that they are just always with the DA, that is going to be a topic that we go over and over. We also use the pretest sometimes to determine how much time we're going to spend on a module. And so some youth, for example, will take a pretest and they'll score 100. And so we're not going to spend a lot of time on that module, if any at all. We might make sure that they have that rational understanding a little bit more, or like that they understand other scenarios, but we're not going to teach it in the same way that we would teach it to a kid who got like 30%. In general, for skipping a module, about 90% is our bar, and then we go over the concepts they don't understand. Our modules are also interactive and they have a ton of activities. So the pre and post tests are not the only ways that we're measuring progress. We're also making them do drawing scenarios, answering questions, role playing, hypotheticals, quizzes, and interactive activities that are geared to understanding both their factual and rational understanding. And our hypothetical scenarios are our primary way of assessing that rational component. We document all of their problems and how they're answering them. We assess repeatedly, and we'll go into a little bit more of how we do that in future slides. Some of the underlying principles that we want everyone working with our youth to have is like rapport is essential. I'm not going to harp on it, even though I think it's the biggest point because we all know that. We also spend some time identifying their different learning styles and trying to accommodate in order to fit that. We've had some youth who didn't know how to read. We had other youth who primarily learned by reading. And so we're going to use whatever learning style they have to teach them. We try and make accommodations for attention span and other needs. So we might incorporate more breaks. We shorten sessions, we lengthen sessions depending on what they need. We match their language. So if they are coming up with metaphors or examples that work, we're going to use those as well to help them understand. We try to highlight their strengths, and we communicate with their legal and treatment teams to also understand what is working and not working with them, and to make sure that we're all kind of on the same page. Some of the primary things that we want to consider is the difference between memorization and understanding. We find this especially with our kids that have autism, that they are very good at remembering the exact definition that I provide them, but they are not so good at understanding what that definition means. And so part of what we train our providers to do is to be able to assess the understanding of these constructs in different ways. And so to be able to say like, yes, that's the right definition. Can you give me an example? Is there another way that you can say it? So that we're sure that it's not just that rote memorization. We also think about like, what is the specific that this youth needs to know versus what is the general knowledge that we need to know. And so for some youth, they might really need to know the process of a waiver or a certification because that is what they're facing. For other youth, they might not need to know that. And so they might just need to know that there are more serious consequences that they could face, right? We want them to know the specifics that apply to their case, but we want them to have the general knowledge so that they're also not just memorizing this one scenario, and I know the name of my defense attorney and the job of my defense attorney, but I don't know what defense attorneys do in general. And then also when we're assessing these questions, we're also always asking, is their answer, is their understanding more right than wrong? And so is this good enough that we can move forward? Do they have the general gist? We also don't need them to say it perfectly or explain it perfectly. We just kind of want to ensure that they know what they're doing. Part of what we're going to do, and part of the reason we have a treatment plan, is that we need to identify their different legal needs. And so in our jurisdiction, there are very different consequences that you can have if you have a misdemeanor or felony case. For example, most of our misdemeanors are not coming to detention at all. And so in our detention center, we only have felony cases and a couple of VOPs, but VOPs of felony cases. Right. We also know that not every kid is going to need the same things. For some of them, a plea deal is going to be the way to go. For some of them, it's going to be trial. If they go to trial, some might need to testify. For some kids, there might be a ton of video evidence, and so we don't really need you to reconstruct events. For others, they might be the only person who was there, and so that becomes a much bigger part. Now, we do teach them all about plea deals and trials and testifying, but for example, we have had some attorneys tell us, like, if they are found fit and we go to trial, their testimony is going to be very important. And so we might spend more time with that kid on testifying. We have other ones where like we know that a plea deal is going to be likely if they are to be found fit. And so we also want to make sure that they understand. Plea deals is pretty big for every kid. I have yet to have a kid where that wasn't a really big focus. And so we also are going to spend different time explaining different potential outcomes depending on what they can face. So for our kids, it could be probation, placement, TJJD, which is the Texas Juvenile Justice Department. It's our worst juvenile placement essentially, and then certification or waiver when they're sent to the adult system. We're going to spend less time explaining what TJJD and certification are if they are not eligible for those placements. We also wanted to give you an example of the kind of questions that we ask in our pre and post tests. And so these are 4 of the questions from module 2, which looks at defense attorneys and working with defense attorneys. Each pre and post test usually has about 20 questions, but we're looking at specific information, like do they know their defense attorney's name? Do they know another word for attorney? Because a lot of times we call them lawyers, or sometimes the kids get confused too between like, oh, is a lawyer just a defense attorney, or can it also be a district attorney? Why? And those are more factual. And then obviously we also have things like, what are some reasons you should listen to your defense attorney? What does attorney-client privilege means? And one of the things that we're doing is that we are using big words like attorney-client privilege, but we're explaining it in simpler terms as well. And so we want to build them up to the vocabulary that they might need. So we just wanted to provide a couple examples of these. This is definitely not all of the ones we do. And what we really wanted to spend some time on was the use of hypotheticals, because teaching for factual understanding is the easiest part. It is just teaching them facts and figures. Teaching for rational understanding is the hardest part, and this is where the hypotheticals come in. And so, as I mentioned before, one of the difficulties that we have in Texas is that this process is not protected. And so we cannot ask the kids about what happened during their offense or anything like that, which makes it difficult to ascertain things like testimony and like, do you understand how serious things were? And so we use hypotheticals, and to make it safer and easier for everyone, we tend to put ourselves as the delinquent actor. I have stolen many shoes in these hypothetical scenarios or other things. We also sometimes create a third delinquent actor of like, okay, Jackie went and did this thing. And so that also helps us to make sure that the kids can apply what they are learning to different scenarios. And we generally just avoid using the youth as an actor. We are going to use similar offenses to what they did, but we're going to change the details enough that they're not going to be likely to incriminate themselves. We also try and get to avoid getting stuck in specifics. And so this is why we're varying it up a little and why we are using different examples. And if a youth is stuck on one concept, we're going to try and explain it a completely different way. We want to make sure that they are understanding different concepts throughout. So even though each lesson is modular, we're going to touch on things that they learned in previous modules in the current modules so that they build up on each other. Now, when I've tried to teach this to people and explain how to do it, a lot of people get stuck because it's hard to come up with a hypothetical, and it's hard to ask a hypothetical because then we'll ask questions like, why should you listen to your attorney, for example, which is an open-ended question, and the kid will say, I don't know. And so we want to be able to teach how to do that. And so generally we start with very open-ended questions and ask kids invariably say, I don't know. We teach them to think about the process of reaching an answer. So the first thing we'll be like, okay, you don't know the answer to that, but what do you know? Okay, I know my defense attorney is so-and-so. Okay, and what is their job? Their job is to help. Okay, so why might it be a good idea to listen? Oh, they're going to help me. Okay, what can they help you with? And so we're going to build the answers until they get to that point. And then we're going to repeat that process several times over different days until they get to the point where they can answer it on their own. Some of the things that we touch upon, for example, in our modules are mitigating and aggravating circumstances, or guilty or not guilty, and different punishments. And so we are eventually going to use all of those together to understand, how do I decide whether I should take a plea deal? Sorry, I'm looking at the time. And so one of the things that we were getting stuck on all the time is like explaining such an abstract concept as a plea deal, because a lot of our kids, that was just too hard for them to understand. And they were doing like, either you never take a plea deal, because if you get a plea deal, you get a consequence, and I don't want a consequence, or you never go to trial because at trial you have to face the judge, right? And that is not the appropriate way to decide on whether you're going to take a plea deal or go to trial. It is also difficult for youth to consider like why a certain time for a plea deal could be better or less risky than going to trial and facing different options. So we came up with what Dr. Walker calls the hat trick. But essentially what we did is we taught them how to do probability. And so for a case, we will make up a case. Sometimes we use fairy tales for the cases. We will write different outcomes, like guilty or not guilty, or in the juvenile world, true or not true. And we'll say like, okay, if you started with just guilty or not guilty and you put it in a hat and you pull one out, how many times do you get guilty? How many times do you get not guilty? Okay. Now let's say that there's some evidence to show that you did it, right? That means that there's a bigger chance that you'll be found guilty. So we add guilty slips. Now do the same exercise. Okay, but what if there's evidence to say that you didn't do it, right? Like maybe you have an alibi. Okay, now let's add more evidence of not guilty. So that's a not guilty. And we vary the scenarios to help them see how different amounts of evidence can lead to a stronger result at trial, right? So once we understand that part of guilty, not guilty at trial, that we can have a good idea of how it's going to go, and still it's not a guarantee, we also look at the final disposition. So then we say, okay, for your plea deal, and we worked with our DAs to come up with some realistic examples of plea deals, like this is the plea deal that they are offering Jackie for whatever. Let's look at all the potential outcomes that you could get if you go to trial and get sentenced at trial. And so we will put those in. And then we look at like, okay, do we have aggravating circumstances? That means that there's more of the serious outcomes. Do we have mitigating circumstances? Yeah, that means less serious outcomes. And so we use that to kind of illustrate how evidence, mitigating and aggravating circumstances, the judge impartiality, all of that comes together to make the decision of pleading guilty, taking a plea deal, or going to trial. And we find that through that exercise, the kids understand it a lot more. And they also understand that idea of like, you could have a good chance at trial, but it's not a guarantee, and like what it means to be able to take a plea deal truly. And so I hope that that was understandable, because I know it's a lot of talking and we didn't have the images for it, but that is one of the ways in which we use hypotheticals. We also wanted to talk to y'all about how this program has been going for us. And so we're gonna use two case examples. I cleverly named them Tom and Jerry. Those are obviously fake names, to kind of illustrate some of the different approaches that are needed. So Tom was a young boy that was diagnosed with autism and ADHD. He was being seen for in-person sessions. He was very engaged. He wanted to participate, but he was very, very anxious. He could not stop thinking about like, but I'm going to get in trouble, but I'm going to get in trouble. And so often we had to redirect him. He had a lot of difficulty with abstract concepts. For example, we tried to teach him his right to remain silent or right to an attorney, and he kept asking us, but what is a right? And so then we had to teach the concept of a right because that was too abstract for him. And he had excellent memorization, which was helpful, but it also meant that it was very easy to assume he understood when really all he had done was memorize. And so with him, we needed a lot more hypotheticals. We needed to make the abstract more concrete, and we needed to ask things in different ways to ensure that he understood, while also making sure that we weren't telling him that his initial answer was wrong, but that we needed him to build on that. Jerry, on the other hand, was diagnosed with ADHD, disruptive mood dysregulation disorder, and he had borderline intellectual functioning. Initially, due to where he lived, we were doing online sessions, and we had very low engagement. He was easily distracted. He had very low frustration tolerance. He was up and around. When he was taking his ADHD medication, he was better able to focus, but often he was not, or by the time we saw him, they had worn off. He also had a lot of difficulty learning things. He would forget what we learned. And so in part because of the low engagement, we would have one great session where he learned it, and then he would forget to sign in the next session or not go or be so distracted that by the time we recovered the concept, he had forgotten what we had practiced. And he had a lot of difficulty controlling his hyperactive behavior. So one of the big things that we needed to do was also focus on how can we control ourselves in court? How are we going to manage these behaviors for court, which was a problem that we weren't going to have with Tom. One of the things that also happened with Jerry and that made us reconsider how we were providing our services were all the environmental factors that were happening with him. If it was raining, they could not access the internet because it was bad internet connection. If we saw him after school, it meant his ADHD medication had worn out, but if we interrupted school, that was negative for like his progress overall. And his mom had a lot of different things going on with her that made it very difficult for her to bring him into sessions. And so those things made it more difficult, and is one of the things that made us think about making sure that we evaluate the families to make sure that we can provide them services in a way that is helpful to them. At the end, I will show you an overall list of who we were and were not successful with. And these are a little bit edited for confidentiality, but just some of the things that show how different these cases can be. Some additional challenges, kind of like I mentioned, is that it's a big time commitment for our families. The kids are tired after school. Because we only have 90 days, if a kid is absent for one session, it's a big sunk from like the 10 modules that we have to do. If we have technology problems, that's also interrupting, and it's difficult to reschedule because we have just such a limited time to offer these services in. The parents can also be a challenge in some cases. Sometimes they just tell the kids the wrong thing, and so then we're fighting misinformation when trying to correct things. The youth might have difficulty accessing services on their own, so if parents are not there to help, that can make it difficult. And we've had at least a couple of cases where parents advocate against participation because they think that if their kid is never fit, they'll never face a consequence. And so we also have to work through that. And then the truth is also that there are limited consequences for how we can manage if they are not participating, right? Judges can admonish the youth or the parent, but often we're relying on parental consequences and on parental commitment to have the youth participate. So if a youth participates and we get to the 75th day, there are two possible things that we can find. Right? We can find that the youth has attained fitness, in which case we are done and that youth's legal proceedings resume. But in the case that we get to the 75th day and fitness has not been attained, we have a couple of options. The first is that we can request an extension, and we have been granted extensions between 30 to 90 days, depending on the needs of the youth and the purpose of the needs. If it's simply that they need a little more time to get it, we might get 30 days. If it's that we had like one of our kids got COVID and was out for so long that we missed like half the training. And so in that case, we got 90 days. So we can work with the judges to do that. There is no clear way in Texas to do that. So it is legally very difficult to do it when we have to. And so we try and avoid that. And we are working to change our legislature so we have more time to do it. In some cases, we might decide that things have changed and now inpatient services are recommended. So the youth might now be in a place where commitment criteria is met or where LEAP is no longer feasible. And so then as they might go through a new FTP evaluation and a new conclusion might be met. Or we might determine that despite our best efforts, they're just not restorable. They have reached their maximum capacity and it is not enough. And at that point, the district attorney can decide to either pursue civil commitment or they can drop the charges. And that is their call to make. Some of our outcomes, we have a very small N. We have had 6 kids between the ages of 14 to 17. Their primary diagnoses have been intellectual disability, ADHD, and autism. Several of them have had other additional diagnoses, but those weren't the reason why they were found not fit. So these are the 3 most common. Of our 6 kids, 4 were found fit. 1 was found not fit and not restorable after several extensions, and 1 ended up needing to be transferred to the state hospital because his mental health deteriorated to a point where he needed to be committed. We have tried all sorts of different kinds of service delivery. We provided service delivery to 2 kids. 1 was successfully restored. 1 was the one who ended up needed to be taken to the state hospital. We saw 2 kids in a detention or subacute mental health unit. So these were kids that although they didn't meet commitment criteria, they met detention criteria, which is slightly different in Texas. So we saw them both here in our detention facility and also at a local mental health subacute unit. And both of them were restored. And we saw 2 kids in the community in person, and both of them were restored. Only 2 of our kids needed extensions. And in our experience, it is when you have a confluence of several factors that led to extension. For one of our kids, it was due to a mix of autism and IDD, and he was just not going to be able to be restored, even though we had good hopes. And for the other kid, there were so many environmental factors that they couldn't adequately participate within the 30 days, so it led to an extension. There are several things that we want to do. As you can tell, this is a baby program. It is less baby than it was before, but it is still brand new. We are working to expand our services. And so we want to provide these services in other counties. And we are working and collaborating with Utah to create a manual that can be not Texas and not Utah specific, so that we can collaborate with others. We have been talking to Philadelphia and Colorado, among other people, so that they can provide these services. The idea is for this program to be free and easily accessible to anyone. And if they want to give us their data for research, that would be great. More close to home, we want to provide some basic legal information to all the youth. And so adapt a couple of our modules to teach it to all the youth in detention so that they understand what a plea deal is. Because as Dr. Walker was mentioning, even if you have the cognitive abilities, you might not have the legal information at that age. We are trying to do more actual research. And so we are aiming for a multi-state collaboration where everyone gathers outcomes. We're trying to look at the efficiency of our tests, but also like, are our pre and post test questions working? Does the order of the modules matter? How long is it taking us to do it? Are there differences based on diagnosis? And hopefully we will at some point be able to come back to y'all with more specific information on it. And then also we are trying to work on policy. We're trying to increase awareness of existing policy so that more and more people know that youth have to meet commitment criteria to be sent to the state hospital. We are also trying to change policy and work with legal workers to expand the length of outpatient restoration. And we're trying to define who can do the work and how are we gonna make it accessible in places that are as resourceful as Harris County, but also ones that are smaller and more rural who might not have everyone available to them. So these are all areas that we are continuing to work on, and we are continuing to try and figure out how we're going to make it work for our department and eventually to share with others. We have had a lot of problems creating this. We have had a lot of successes, frustrations, and we hope that other places are going to start looking at fitness attainment programs for their youth too, because this is a need that is not yet being met. And so if/when you have questions, feel free to reach out to us as well. And I think that's all we have. We do have our information here and some resources that we mentioned, but you can look up for yourself. But yeah, Anthony, I think we are ready to answer questions if you have them.
Yes, thank you so much, Dr. Iturri and Dr. Walker. I can tell from the questions that have already come in here too, people are very excited about hearing about this program and the prospects of it, and thinking about the importance of these services in other communities too. So we do have several questions here. I might try to merge some of these in certain themes. In the meantime, of course, anybody that's on the call, if you have any other additional questions for our presenters, feel free to enter them in the Q&A box. I will do my best to get through as many different topics as we can. So the first one, I'm going to kind of combine a couple that some people asked that was related to the context that you provided, that you're unable or not allowed to discuss the youth's charges with them. And several people were asking about potential obstacles in restoration and how that might be affected. And one particular question was, how do you go about working with youth in that context when they're presenting with rational deficits related to their case? And they provided an example, say they have delusions that the person they assaulted was an alien, so I don't have a charge because I was assaulted by an alien, not a person. But if you're not able to discuss the charges with them, how do you address that?
That's a great question. And I have an unsatisfactory answer. And it's that we haven't had to deal with that yet because most of our youth are not here for psychosis. And so because most of our youth are found not fit due to IDD or autism or things like that, that has not come up for us yet. I don't know what we would do exactly. Sometimes I think we could probably find a way around it or get permission to talk about it through their attorneys or things like that. For the most part now, we've been using hypothetical scenarios, and if they do tell us something, we are thoughtful about our documentation.
Thank you. Someone else asked.
Wait, sorry. We're also trying to change policy so that we don't have to deal with that. Is the long-term solution.
Sure, certainly. Overall, what is the incentive for youth to participate in the program if they have a lack of trust in the system? Have you come across any of this resistance?
Yes, boy, have we. For the most part, we try and build off of the rapport. We are also not above giving them things that they like to sit with us. So like we will give you snacks, we'll play music, we'll try and make the process fun. And then we'll explain to them what can happen if they don't participate. They don't particularly like going up to the judge and having to listen to the judge tell them like, do this. And in general, we've been able to over time build trust with us and like explain like, you don't have to trust us, you don't even have to believe this, but can you sit here and do it? And the longer we're able to get them to tolerate just sitting here and learning the process, the more usually over time we're able to get them to engage. And we do a lot of the same things that we do when we provide therapy to kids who don't want to talk to us, which is being very forthcoming and not lying, and building on that relationship. Dr. Walker, anything to add?
I was going to say, so I know we're working on having, I guess, like flyers or documentation, really just trying to get more information out to our attorneys and judges too. And hopefully with getting kind of a better understanding of our program, attorneys can also kind of help with that and explaining to their clients kind of the benefits of participating in this program too. So working with the attorneys as well, because we have had that situation come up and we've had to consult with the attorneys before.
We have several people that are curious about some of the logistics, particularly some financial logistics. And I've seen several people ask something to the effect of how is the program services funded, and specifically how much is it funded by the courts versus are the parents of the youth responsible for funding some of this? How does this work in your program?
That's a great question. So right now, the way that it works is the parents don't pay anything for it. And all of the people who are providing the services were already employed by the county. So myself, Dr. Walker, our interns, Dr. Shibwezi, we were part of the forensic unit, which provides forensic evaluations for the youth. And then we created the program and we just took on this extra job. Long term, this is not going to be a feasible solution to serve all the youth that we need. And so we're looking into grants and things like that. But the aim is forever for the courts / the county to be the ones paying for this program. And it is not something that we expect the youth or the parents to have to pay for.
Thank you for that. Somebody had an additional logistic question with parental resources, saying that regardless of the financial part, if particularly low-income families who don't have internet access or access to travel to meet in person, are there other ways that services could be rendered? Community services are so limited already that those may not be easy fixes.
Yeah, we've tried to problem solve, and it's been case by case basis. For one of our kids, their probation officer went to pick them up and drop them off. For others, we have gone to meet them at the facilities where they were at, or at we have something called CUPS units, where it's like their probation building in their community. And so we will meet them there, which is closer to them. Thankfully, so far, we have been able to find a solution for every kid, but that is one of the things that we consider when we're doing our initial intake, is how are we going to facilitate this? And we try and come up with creative solutions. It has mostly worked because we have an N of 6.
Speaking of that N of 6, or I think for this question, it might actually be an N of 4. And for limited, if there's limited time where you have no answer for this, that's certainly okay. But someone was curious about what the retention of restoration status has been for those that were restored to competency, whether over like 3 months or 6 months or so, or anything like that.
For 2 of the kids, it's too recent to tell. For the other 2, they were able to do well enough 3 months after that their cases were resolved, and we never followed up with them since. But they haven't come back to us, so they're fine.
Have you had any experience with a youth's caregiver or parent who just flat out would not consent to the youth receiving treatment?
No, we did have a parent tell their youth not to participate, and eventually we used both their defense attorney and their guardian ad litem to talk to the parent about why that was not beneficial, and in the end they changed their mind.
Any eligibility issues in terms of does the severity of the crime committed or alleged to have committed determine acceptance into LEAP?
No.
Let's see. Several comments about you've done a nice job highlighting pragmatic challenges of the service. Who addresses these case management issues during attainment? Is it the same professional providing attainment training service sessions? There you go.
No, so ish. I don't provide the attainment services. We have wonderful interns and our postdocs who are doing the actual service providement, and I do the case management / supervision.
I also just wanted to go back to that question about does the nature of the offense or their charge affect the ability to receive the services? So again, no, but it may affect the service delivery method. So you with more severe charges who may, again, meet those detention criteria will most likely be seen in detention. So we do kind of consider like what you may consider like jail-based restoration services as under our kind of umbrella of outpatient. So those may be more likely seen in our detention facility rather than in the community.
We had a few questions about your discussion of the pre and post tests that you use, and some ones just more open. Can you talk through that a little bit more? And then somebody had a particular question about, do you do pre and post tests for each module versus more of a holistic approach?
Yeah, do you want to explain, Dr. Walker?
Yeah, so it's module specific. So again, we do that at the outset before we start each module. And then after we've kind of reviewed all the content with the youth from the module, we'll go back and do the post test. And that, like Dr. Iturri mentioned, may highlight areas that we may want to address during the review. But we do have one for each module. So there isn't kind of like a total kind of in the beginning of the services and the end of services. It's just module specific.
We use a mix of open-ended and multiple choice questions as well. And so it's the same questions for the pre and the post test. And then depending on how they do, we either stay on the module, move forward, or review more.
What do you use, or how did you develop the initial assessment that you use? I guess the pre in this case.
These were taken originally from the manual created by Utah. We have now collaborated with them to revamp our questions. And so that came through several psychologists and other providers who were doing the sessions, looking at each module and deciding like, what do we need to ask about this module to ensure understanding? One of the other things that we didn't mention in this presentation, because as different state to state, is that we also use a program called Nearpod, which makes it interactive for our youth to be able to participate. Utah uses Kahoots. And so our questions are also embedded in that program, and it's more interactive that way. But the content of the questions originally came from Utah and have now been based on like our discussion together.
About how many states you say have services for juvenile competency?
Formal services, I think we had a slide. I know that some places do it informally. They will just have like someone try, but I know that Utah, Colorado, Florida, Texas, Pennsylvania, and Virginia have some sort of formal services. So that's 6. There might be others and we just don't know. Those were the ones we were able to
apologize for
find.
missing you.
Yeah,
if you're out there, sorry.
Seems like it's more the exception than the standard right now, at least. Zooming out a little bit, somebody's that's I get asking more about competency broadly. Is competency a legal determination or a mental health determination? And could you discuss the difference between those?
Competency is a legal determination informed by a mental health situation, is how I would say it. And so it requires mental health mental health diagnoses. In Texas, a very specific type of diagnoses. But it is a legal determinant because it's whether you rationally and factually, and those are legally defined terms, understand several different key constructs. And some states have very specific lists of constructs, others go more generally by Dusky. Each jurisdiction tweaks it a little bit, but it is a legal construct overall.
And also just wanted to add, I think in one of our slides, we had at least Texas specific, like a legal definition for mental illness. And while we are allowed to opine ultimately on fitness, which again is jurisdiction specific, the judge does ultimately make that determination.
Thank you. One person asked about how you manage malingering or suspected malingering or feigning of deficits in these contexts. And one specific question they had here is, I wonder how you manage that within the group context. One person is quote unquote faking bad, and it's clear to the group they're doing so. How do you manage or address that?
I'll let Dr. Walker speak about the malingering piece, but I will clarify that we don't offer group services right now, so we don't deal with that. But I'll let Dr. Walker talk about the malingering bit.
Yeah, feel free to chime in too. So at least in, I guess, like my N of one experience with my youth, I would say it wasn't really like malingering, but again, just those attentional difficulties when it comes to, I guess, and more motivation rather than kind of outright malingering. So at least in my experience, I haven't really had to deal with that. Dr. Trey, I don't know if you're aware of kind of any other youth. It was more so motivation, I would say, which Iturri kind of spoke to. You know, sometimes that may come from the parents and that may come from the youth as well.
I know that our evaluators, when they do their initial FDP, would consider malingering, and they use several of the tools outlined by the folks on like how to do that, asking different kind of questions. There's some things that you would expect a youth to know. If you are suspecting malingering more on the like IDD side of things, you might do testing to also check for things like that. If you're suspecting that they're trying to fake IDD or something like that. With most of our youth, the problem we have is lack of effort. But it comes from such a like youth place of like, I don't want to do this, that it's not quite the same as malingering. And then we deal with it with incentives like we talked about before.
Well, Dr. Iturri, Dr. Walker, thank you so much for sharing this overview, this inspiring work that you've been doing for competency restoration for youth, and also that the program specifically that you have directed, that you'll continue to work on. We thank you for that, and for all the information that you've shared that I think has both informed people and also inspired some people, hopefully in other agencies and jurisdictions for their own services. That wraps up this week's Law and Mental Health series. Stay tuned next week when we have Dr. Tina Zatoli, who will be discussing competency and validity issues among youth that are accepting plea deals. Until then, I hope you have a fantastic rest of the week and take care.
Thank
you.